Hey guys, when a parent includes a child as a joint owner of a property out of convenience, but the parent doesn't intend to give the property to this child, a legal dispute could ensue. For example, in this case, a HDB flat was in the names of a man and his daughter. When the man died, the daughter automatically became the sole owner, to the dismay of her 6 sisters and a brother. They fought over the 3-room flat because the father's will stated that it would go to his only son. The daughter, who was the joint owner, won her case in the High Court because it ruled that she could inherit the flat as the joint owner. But the Court of Appeal overturned this decision because there was sufficient evidence to show that the man did not intend for his flat to go to that daughter. It then granted the family's request that the flat to be sold so that the proceeds could go to the man's son, according to his will. To prevent family fighting over a property, here are 3 things that parents could do. Number 1. Use power of attorney. If elderly parents want their children only to help them manage their property, it's better to set up a power of attorney, a legal right to do things on behalf of the parents, instead of including them as joint owners. This will prevent the property from going to the joint owner child because he or she was not the intended inheritor. Number 2. Giving shares in the property. A parent can add a child as a tenant in common by giving him or her a share in the property. In this way, the child will not be able to inherit the whole property when the parent dies, as the remaining shares in it will be distributed according to the will. Number 3. Be transparent in your arrangements. If a parent wants to add a child as a joint owner but does not want him or her to be the sole owner upon the parent's death, it is vitally important that this intention is recorded in unambiguous terms. It is important for the parent to state this intention clearly because such transfer will usually be treated under the law as a gift from the owner to the new joint owner. Of course, you can state the purpose of such arrangements in your will or even create a specific document outlining the reason for the transfer. The new joint owner can be asked to sign an acknowledgement that his name is included purely for administrative convenience and that the parent has no intention of giving him the property. Finally, it's prudent to be transparent with your intentions, such as sending an explanatory email to your beneficiaries, as the courts have accepted such communications as useful evidence if any dispute arises. More importantly, the family will be better off if you are around to put an end to any discord that arises as a result of your wishes. Hope you learned something today and see you in the next one.